The pre-trial conference into the murder of a slain teenager, Nathaniel Julies, was postponed this morning at the High Court sitting at the Palm Ridge Magistrate's Court here in the east of Johannesburg. Nathaniel Julies was murdered in 2020, allegedly by police officers just meters from his home. He was shot allegedly outside his home at sunset. According to the police's version of events, they had assumed he was a drug dealer in the area. However, this was a young teenager. He was shot and then taken to hospital where he passed on. The trial did begin last year in October. However, due to the unforeseen passing of the presiding judge, the matter has to now restart. To get more context into the laws that surround these kind of issues, I want to bring in the NPA spokesperson, Pindim Jananwane. Thank you so much for joining me this morning. Let's start with, why was it necessary for this matter to now restart from the beginning, despite the state already calling at least 4 witnesses and the trial already starting?
Well, unfortunately, Hasina, its procedure, the law dictates that the matter should be started afresh. There's a difference between a matter that has been heard until the conviction stage and a person has been found guilty, and maybe a presiding officer then passes away whilst awaiting to deliver sentence. Then that's an easy one. It can then be taken over by the next presiding officer, use the record of proceedings and deliver a sentence. But in this one, it was a part-head matter, and the conclusion that this court is expected to come to will include, amongst others, findings about the credibility of state witnesses. And to make such a finding, a record of proceedings alone would be insufficient. The judge will have to make their own observation in terms of the demeanor of the witnesses that are before court, how they conducting themselves, the non-verbal communication that they do, the gestures that they do when maybe confronted with difficult questions. So therefore it's important that the trial starts afresh. It's for the benefit of both parties, both the state and the defense, because remember, such criminal cases are likely to go up until the appeal stage, and we know that the appeal courts will have to consider the findings made by this court, and therefore it's important that such proceedings happen in this manner.
What next with this process after that pre-trial conference, which has been postponed to in June? We've been told there's a date of October set. Talk us through what happens now.
Well, from here onwards, firstly, we have to go through the stage of a pre-trial conference. Remember that the pre-trial conference is held to avoid unnecessary delays. The judge will have to find out if there are any disputes, what the parties agree on, how many witnesses each party will call, so that the judge can then determine more or less how many days do they need to set down the trial for. So after that stage, we'll then set a trial date once the court affirms that all parties are ready to continue. We'll then set a trial date, and then after the trial date, obviously it will have to be the pleading stage, plea and trial, and then trial begins. We then call our witnesses as the state. They are cross-examined. Then we close our case. The defense does the same, call their witnesses. We cross-examine their witnesses, close their case, and thereafter we go into the argument stage in closing our cases.
When it comes to the trial restarting, does the councils now have the opportunity to call different witnesses that they may not have had in the initial trial, or would the process still stay similar to those kind of witnesses that were on the list already and the statements that we've seen before, or do they have the opportunity now, if they want, to bring new witnesses?
Well, the process remains the same because remember that starting the trial afresh is not an opportunity for either of the parties to then try to fix what they could not fix in the previous trial. So it's basically the same process that happened previously. That is why each party is able to then use the record of the first trial should there be a need to do so, or should the need arise.
There's been many delays already and postponements, with this matter. It finally went to trial in October last year. What message do they have to the family who's waiting to see this justice being served?
Well, we firstly wish to extend our apology as the NPA, especially to our witnesses and the family, for this unforeseeable delay. It was beyond our control as the NPA. We understand the need for justice. We understand that the family cannot wait to get closure, and it was our wish as the NPA to bring this matter to finality as soon as possible, but unfortunately we had to go through these unforeseeable circumstances, and therefore we would like to plead with them to practice patience and understand that there is this need that the matter be started afresh for their own benefit as well.